So that shows immediately probably that I have a different way of addressing an audience being a teacher. And so more and more I use images and I believe they may help to bring the message across. Now, the basic question that we want to answer, as I understood it at this summit, is what could the role of international law be in promoting human rights? And so my short answer to that is, well, it has quite some potential, but only if we also revisit international law, in particular international law as it applies to human rights, or what we call international human rights law. Why do we need to revisit it? Well, I think taking a more empirical approach there, what we see is that clearly there are major power shifts and there is a clear dispersion of power. And rather than sticking to our traditional, it was already referred to, Westphalian notion of there's only one player in town, the state, and we have 200 states or so, and so these are the only actor we have to focus on, as international human rights law does up to today. I believe we have to move beyond that point and also address the other power players that are now out there, and we have to rethink human rights law accordingly. Now let me give you four issues of situation, so I hope we are now on the third slide, and the first image. So if you click once more, thank you very much. One of the issues that brought me to this topic and to my argument is that my country, Belgium, where I'm based at the University of Antwerp, as you may have noticed meanwhile, and which I forgot to mention by way of introduction, when Belgium decided to continue to support primary health care in a number of its developing partners in Africa. It said, we are fine to continue our support to your health system, but we want you to introduce user fees. Patients have to pay also, partly for the health care they are getting, because otherwise you will never be able to have a sustainable health system. And so did a number of these partner countries, with the consequence, as documented quite strongly, with the dramatic consequence that healthcare use dropped dramatically. 50% of the patients no longer attended primary healthcare services, but also easily treatable diseases again rose quite dramatically in these areas where, due to Belgian encouragement, if not pressure, user fees had been introduced. Second example, where we may wonder whether we can stick to this idea that the human rights obligations simply lie with the state that is, formally speaking, the state in charge, the territorial state, is the economic and financial crisis, and what many observers now call the humanitarian crisis that followed, in particular in a number of countries in the south of Europe. And here you see Italian people demonstrating, taking to the streets. Can we reasonably, legitimately argue that if any human rights violations occur, and we have meanwhile the first judgments establishing and the first decisions establishing that there are violations of the right to healthcare, to education, to social security, through the austerity measures that were introduced, can we argue that we should only go after the state that took the austerity measures, Italy, Spain, Portugal, Greece, typically, or should we also look beyond these states to see what the human rights responsibility is of the EU, the Eurogroup, Troika, and the International Monetary Fund, for example? Third example, and people already mentioned the invasion in Iraq, and that's one of the pictures on the invasion in Iraq. If we send troops, military troops, if we have boots on the ground in other countries, and armies engage in either occupation or what we call peace operations. People get killed, typically, people get arrested, and there may be huge impact on also socio-economic rights, as was illustrated, for example, in Kosovo, in a number of cases. Can we then stick to our traditional and still strong idea within human rights law that this is the problem of Iraq, because that's the territorial state? Or do we need to look into the question, what is the human rights responsibility also of these powers that invaded, occupied, keep peace in these countries? And in particular in this field, in this area of civil and political rights, right to life, prohibition of torture, right to freedom, and so on, we do now have quite established case law of the European Court of Human Rights, accepting that exceptionally we also have to talk about the human rights obligations of these external, these foreign states. Fourth and final example, the example of exploitation of natural resources, open pit mining very often, where we have more and more evidence how that impacts often negatively on property issues, on right to water issues, and so on. And again, the question from a human rights perspective, do we then satisfy ourselves by saying, well, if any human rights obligations occur, it's the problem of the state where the mining takes place, typically very often a developing state? Or do we have to look also in the question of human rights obligations of companies involved and the funders of the companies and possibly the home state if we are talking about transnational corporations? So that's the big question in a way that is on the table, and where you know already from my introduction that I believe that we have to take steps forward. Now, the traditional answer to this question is really that we focus on this one and single actor that is out there, the state, and that we look then into one of these states, in particular the territorial state. So in a way we reduce the whole idea of human rights accountability as a question of our traditional map of how the world looks like, a map where we only see states as the actor involved. So what I want to argue here, next slide please, is that given these realities on the ground, human rights law is bound to also develop, evolve further, so that it is more up to the task of addressing these human rights issues. This is not to say that I'm a naive believer in the power of law or human rights law, so that won't solve all questions, but I think it's a necessary precondition in order for human rights law to remain relevant in many of these clear issues of human rights and human rights violations, but which technically and legally speaking we do not manage to conceptualize as such for the time being. So who are some of these other actors that we should bring in? We have companies typically that we should bring in, but we also have, for example, the actor that probably least accepts that it may have human rights obligations, the International Monetary Fund, as one of the Bretton Woods institutions that is very much involved in funding. But there is also the tricky question of, for example, the United Nations and peace operations having human rights obligations. And very often people don't feel comfortable with that idea, because the idea is that peace forces, peace operations do the good thing, and they take risks. And they risk their own lives as individuals. And so we shouldn't talk about their human rights obligation, the argument often goes. It will also kill peace operations because states will no longer be available for offering troops, for example. The argument further goes. Well, we do see that more and more it is accepted that also the UN and or the troop contributing states do have to accept their human rights obligations. There is this evolving case law of the European Court of Human Rights in which that is accepted. The UN itself has accepted that, for example, in Kosovo, where at least for the civil administration, UNMIC, it established for the first time a human rights advisory panel to monitor the human rights violations committed by the UN presence on the ground. And now that we have an EU presence there, again, a monitoring body, an internal human rights monitoring body was set up. So certainly there are hopeful developments, and clearly we need to go down that path further. Another actor is, of course, the World Bank, and the World Bank has already accepted some human rights responsibility, also set up some own standards, safeguard policies they are called, and its own monitoring mechanism to a certain extent. But as we heard earlier, you have these dilemmas in real life, and now that in many ways the World Bank is at risk of marginalizing itself because other actors, like, for example, China, are very happy to offer financial support to states without any conditions attached. The World Bank is itself also now thinking again about downplaying its own safeguard policies. And a final actor that I want to mention, not to be exhaustive, is what we call the non-state armed groups, where there is certainly a lot going on. We see the atrocities that may be committed by armed groups. Very often armed groups are afterwards also called liberation movements. So there again there are dilemmas, but there too, whatever the beneficial way we want to look at them, sometimes it is important to also bring them on board in human rights law. So the basic message I'm trying to bring across is that if human rights law is to be relevant for the promotion of human rights, not as a legal concept, but as a moral concept also, we have to move beyond our territorial thinking, and so think about the human rights obligations of states that are extraterritorial, and we have to move beyond the state as the only actor we can focus on, and so discuss what we have termed in academia transnational human rights obligations. And so to end on a positive note, because I've heard in the last hour or so that I was in the room, mainly the challenges we are facing from a human rights perspective. So let me try also to say a couple of words on where we are now. On the final slide, which is a screenshot of a website, Glotro, which kind of documents the academic efforts that have been undertaken so far in really also thinking through from a legal perspective these extraterritorial and transnational human rights obligations. And that brings you to very legal technical questions that I will not bore you with at this moment, but that are certainly the key questions to be raised and answered if we want to see human rights law further evolve down these lines. Let me also say, by way of ending my presentation, that there's also a strong recognition within civil society of the importance of developing our human rights understanding further from this perspective. And there is what is called an ETO, an Extraterritorial Obligations Consortium of academia and civil society, in which these ideas are further explored. And there will be, towards the end of February, a European meeting also to further explore these questions and see how we strategically can create alliances between civil society and academia on this point. Thank you very much.